Ladies and gentlemen, allow me to bring to you
Supreme!
What's up, everybody, and welcome to a new episode of the Supreme Decisions Legal Minute Podcast. And this is your host, Supreme Decisions. And today, I want to go through something that has come up a couple of times and is actually going to be like a three-part series. Considering you have to understand the context of it, but I'm going to give you the first part of it. Now, what I'm talking about is a video that stemmed from another video where I was in discussions with a young person that dealt with the ideas of contempt. Because a lot of times we often go to court and we find out that the judge will say, oh, well, I'm going to hold you in contempt. And most people have no idea what contempt it is they're being held in, what the grounds are. And oftentimes you'll find, just like this young woman did, they would state a state code while knowing that Supreme Court cases and federal codes govern law, as well as the selective incorporation doctrine, which actually ultimately determines what a state can and can't enforce. And this was something that actually was brought up whenever I was watching a Amazon Prime show. I guess that's what you can call it. And it's called Goliath. And it's with Billy Bob Thornton. And as far as Monsters Ball and all that good stuff, that's what actually got me to start watching anything he's doing. And then watching this, I wanted to see if they actually had any real law that goes into the show. And what I like is most shows like this, generally their first season, they do have law that goes into what they're doing to kind of rope people in, but they don't get too deep. Well, the one thing I do love about this show, Goliath, is the fact that it does have law in it. I believe it's 3 seasons now. And he goes a little bit more in depth into the law because he's talking about the practices. And it kind of gives you that window onto the inside. Well, the reason why I'm going on about this is the fact that he was charged with contempt. And he spoke about contempt triggering a hearing that can be brought up and what can be assessed at those hearings. Now, in the most part of this, you have to understand again, is it civil contempt that you're being charged with or criminal contempt? And both of these are aspects that were discussed at the Supreme Court level. I'm going to get into that now. And we're going to go into, in some states, those who violate court orders can be punished by privately initiated proceedings for criminal contempt. Now, even in the first context of that, in some states, those who violate court orders can be punished by criminal contempt. Now, a lot of times you hear about that when you're talking about something such as a child support order, or you have someone that has violated a restraining order, or things of that nature, because those are things that are already in place. And that's the end around whenever they're talking about incarcerating you for child support, because you can't be incarcerated for a debt, but you can be incarcerated for a criminal contempt. So what has happened is most places the forbid such an arrangement because the complexity of the criminal contempt and how did you come to that. This is another one of those instances where I speak about challenging those aspects. I'm going to go deeper because right then I know I realized I actually jumped, because even in my notes that seemed kind of odd for me. But bear with me because I'm going to come back to these very statements, which are generally the first things that came up. The Supreme Court has instructed the federal courts to appoint only disinterested private prosecutors when exercising the inherent authority to punish contempt. So the greatest question that can be asked, who can bring a criminal contempt proceeding? Because one, the Supreme Court stated that it has to be someone that is disconnected from the case to start off with. Two, we have to have a complete understanding of the word standing. Because for standing, there has to be a direct injury directly coordinated by the defendant that the accused is receiving or has received. So when you're talking about criminal contempt, where can the injury come from? The easy is court orders. It has to be in place prior to the contempt charge. I'm going to say that one more time. The question that was brought up by the Supreme Court was, who can bring up a criminal contempt process? It has to be a court order, and it has to be someone outside the matter. And the order itself has to be in place prior. Any victor in a civil suit may someday undertake a contempt proceeding to preserve the victory. Multinational corporations seeking to protect its patents, a parent attempting to enforce his or her custody arrangement, these are prior orders. These are where things can be set up for examples as places where contempt can be placed. And here's the craziest question about this. Why is the question itself even being asked for the distinction? Why was it asked for the separation? Because the doctrine of contempt assumes that civil proceedings will be sufficient to enforce court orders. I'm going to say that one more time. The doctrine of contempt assumes that civil proceedings will be sufficient to enforce a court order. So it means the order itself has to already be in place, even when we're talking about the Supreme Court arrangement for this. Because criminal contempt is distinguished from its civil counterpart in that it punishes non-compliance rather than merely encouraging compliance. The punishment of an action or a non-action. To jail a contemptor for what he or she did last Tuesday is what criminal contempt is required for. Because it has to be something already in place. There has to be an agreement, an acceptance of an offer. There has to be something there prior before there can be a criminal contempt. A civil contempt is something that is set forth in order to begin something. It's going to be in place to enforce a order that they're looking to achieve. Because the Supreme Court discusses the question of who can initiate proceedings for criminal attempt, and if it were possible at all, because again, we have to understand the ideals of standing. There has to be someone receiving an injury. Now, when we talk about the context of Fork and Fork, it's a 1998 U.S. Supreme Court case that deals with contempt orders. But then we go to Buck Stove and Range Company. It's a 1911 Supreme Court case where they go into the ideals of protecting something through contempt. Why? Because there was already an order in place. Now, who's one of the people that you actually go to when all of this stuff is going on? Because most people didn't even realize that the DA, the district attorney, has a boss. It's not the people. It's the state's attorney general. Guess who else has to answer to the state's attorney general? The governor. But when you talk about the state's attorney general, because I'm going to get back into this, the state's attorney general is the one who enforces both local and federal criminal laws in the district. The state's attorney general is one who enforces both local and federal criminal laws in the district. When you're talking about these, or when you're talking about actually contesting or fighting back on these contempt allegations, contempt charges, and it's not done properly, because we see it oftentimes it's not, and mostly because most of these people have no clue of how to actually do their business. These prosecutions violate the due process rights of the person or people involved in the action. Because when you don't have a separate counsel, an outside counsel, or someone that has no ties to that particular hearing or judge or matter itself, there is a conflict of interest. And that is through Young v. U.S., which is also a Supreme Court case. Because you have the due right of due process to disinterested public prosecution. The narrow holding proposes does not address civil contempt proceedings or consider more generally the legitimacy of existing regimens for the enforcement of restraining orders. And this is actually one of Sotomayor's writings. When you're talking about contempt, and you're talking about the briefings that they have, this is why you do that. Because even they understand the complexities of the things set before them. Because they're not making a decision just for that matter. They're setting out an overlay of all matters that are similar, or in similarity, or similar. Because you remember, I constantly tell you, law is not subjective. The law is not subjective. It's situational. Because each situation has a different form of how it is being played out. Which is why when you have Terry v. Ohio, you also have Arizona v. Gantt. You also have all these other contexts that goes with it. Davidson v. Mississippi. Because all of those deal with Fourth Amendment violations. But they deal with them in a separate subject. It deals with them in a separate situation. But it all deals with the same context. Which is why it's not subjective. It's situational. Because in this situation, this is where it applies. In that situation, this is where that applies. That is what I am trying to teach. That's what I'm trying to bring across to you. I'm showing you where it applies, not necessarily where it's taught at, or giving you the whole breakdown of each and every case, because you don't apply every aspect of each case. Do you go deeper into some cases than you do others? Absolutely. But are there other instances where you only need the actual decision to enforce the application which you're looking at for your situation. Because even in Part 3 lays out the possible constitutional objections of such an enforcement mechanism. Because it argues that in narrowly all cases, privately initiated contempt proceedings are constitutionally problematic. When you talk about the layout of possible constitutional objections to such enforcement mechanism, because it argues that in nearly all cases, privately initiated contempt proceedings are constitutionally problematic. These are the things in which we talk about when we talk about something as simple as child support. Because each one of us know there's no real truth behind why there is a child support enforcement agent, or why Department of Family and Children's Services is involved in a collection action. Because when we're talking about judgments, and we're talking about contempt, and we're talking about semantics of words, because the words have power and we're not paying attention to them because we're belittling them by abbreviating, by changing their meaning to you. Because in court, the meanings haven't changed. In court, the meanings and the words themselves have not been broken down or abbreviated. They mean what they are written as. They are enforced as what they are written as. Your understanding needs to be how it is written. And even in the context of those that want to be biblical, as it is written, so shall it be. These are the things that most of us have to understand, because we're talking about in the context of family law and domestic cases. Because the central to the vindication of rights protected by the court orders. But the problem are the orders themselves. Are they set up properly? Are they adjudicated properly? Are they brought forth properly? Well, if anybody that followed me for any amount of time, listened to anything that I've said, understood anything that I've brought across, you understand that proper is the problem, because it's not done properly, because it's not done orderly, because it's not brought out as it should be. And a court that issues an order must be, and in American law always has been, able to compel obedience and punish disobedience. But the problem is the doctrinal paradigm, a criminal contempt to punish public affronts, and civil contempt to enforce private rights. Child support is looking at as a civil contempt violation. The problem is, when we're talking about it, they speak of it in forms of collection. They don't speak of it in the forms of protection. I'm going to say that one more time. They speak of it in the form of collection. They do not speak of it in the form of collection. God damn. They speak of it in the form of collections. They do not enforce it in forms of protection, which allow for jailing for criminal contempt. Which is why when it spoke up here and it said almost all criminal contempts are violations of the Constitution. Why? Because the enforcement is not done properly. And when you're talking about disobedience and those that are being subjected to something, criminal disobedience is that for protection. There is no protection when you're talking about a collection of money. You know, I actually might have got a little too deep right there, but I want you to understand something. Because the reason why I'm giving this to you the way I'm giving it to you today is so you can understand something. There are a lot of things that can be said. But the whole thing becomes problematic when you have the one place that you look for answers and they don't have it. I'm going to say that one more time. It becomes problematic when the one place you look for answers doesn't have it. So when I give you a understanding, or I give you verbiage, or I just throw something out and it sounds crazy, trust me, I know it does. A lot of what I say sounds crazy until I can show it to you again. I'm going to say, until I can show it to you again. Now, are there, I guess, forms of context? Because oftentimes you'll see a judge hold an attorney in contempt because they're being belligerent or they're doing things which I call excited utterances. Because you can't take certain things away once the jury hears them. You can't change things that the jury is looking at. You can't take away something that's already present. But you can take over the narrative of how it's perceived. And a lot of times when you do that, you have things that are people that are shouts out obscenities at the court and is imprisoned for the offense is the paradigm criminal contemptor. Here's the problem. There's no order in place. So how can you charge someone with criminal contempt? And if you are taking one's liberty, there has to be adjudication. I'm going to say that one more time. If you're taking someone's liberty, there must be adjudication. So when we talked about Goliath, and the judge charged him with any type of contempt, it triggers a trial. You have the right to a bench trial or a trial by jury. You have the right to get discovery. You have the right to prepare a defense. You have the right to a vigorous defense. Anyone practicing law, say that one more time. Anyone practicing law understands that. And anyone that has any type of integrity understands that. Because even when you talk about one state argument, the Supreme Court differs unless it's during a trial. The only time the Supreme Court has allowed for someone to be jailed for criminal contempt without a prior process being in place is during a trial. It didn't require a court order because you had an agreement of integrity. Shouting obscenities is not showing integrity because he that can't control themselves need to be controlled. And when you're showing levels of I'm just going to curse just to be cursing, use profanity just to be using profanity, you're showing a lack of intelligence. And guess what they want? They want you to be ignorant. They want you to be a ward of the state. They want you to show that you are incompetent and you are unable to do the things that are necessary for you to be successful. I'm going to say that one more time. They want you to be incompetent. Because if you're incompetent, they can do whatever it is they want with you, which is why they're dumbing down our educational system, which is why they're putting us in places where we can't even punish. The brain remembers two things, pain and pleasure. Everything else in the middle of that is just filler. But now I'm going to give you something that while I give it to you, it's going to sound stupid. See, I gave you that just so we can talk about incompetence, and then I give you something that sounds stupid. We're going to talk about sui generis. a crime in the ordinary sense. And in most cases, it's Latin for unique. That's what contempt is. It is a unique crime. It is a unique setting. Because those accused of criminal contempt must, like ordinary criminal defendants, be proven guilty beyond a reasonable doubt. That's why it's unique. Because those accused of criminal contempt must. Remember we talked about the power of words. Must, all of us know what that means. Like ordinary criminal defendants, be proven guilty beyond a reasonable doubt, because you are innocent until proven guilty, or until you decide that you are not. In a proceeding where they are afforded the presumption of innocence and privilege not to incriminate themselves, as well as given notice of the charges against them and provided with the assistance of counsel. Yes, I just paused for dramatic effect because, again, why can't the judge just offer contempt without distinguishing? Because the order has to be in place. And if he's charging you with criminal contempt, just like any other person that's being accused of a crime, you must be proven guilty. It has to be someone else that adjudicates it, not the judge that offered it to you, not the judge that jailed you for it. And there has to be a hearing and privilege to not incriminate yourself, as well as given notice. See how all this stuff starts to flow in? Because if charged for a non-petty offense, criminal contempt defendants have the right to a jury trial. All criminal defendants are protected against double jeopardy. United States v. Dixon, 1993. 509 U.S. 688. And just as most other crimes that are unique, those accused of criminal contempt in federal court have no right to a grand jury indictment. Why did I bring that up? Well, I'm going to give you a story. I didn't give you one last time. I'm going to give you a story. There was a time where myself and someone else was standing across from me, and we were standing in front of a federal court judge, and the conversation was, well, actually it wasn't a conversation. I was reading off a motion, and the defendant yells out, "Well, you can't do that because of this." I then yell back to the defendant, which I'm not supposed to do, "Shut up, the adults are speaking." Now, the judge had every right, because both of us were being indignant while doing what we were doing. Because we had already gone into an agreement that we were going to be adults walking into there. We were going to carry ourselves as human beings, and we did not. But what happens is, even in that instance, you are not afforded the right to any type of grand jury hearing, me or the defendant. Because you remember in the Constitution, you can only be brought forth on charges via indictment. There has to be an indictment, but that's not afforded to you in federal court on a contempt charge. Because if a contempt is committed in open court, a judge may summarily punish the contemptor without a hearing, counsel, or the opportunity to call witness. Criminal contempt proceedings may be initiated in the court's own motion. No executive involvement is required at all. And again, this is federal court, not state. This is during a trial. So the necessity of a notice is not given. Why? Because the orders are already in place, because that's why you're in trial. And in this case, because you're already in trial, a counselor not working for the government must be there. But in this case, as a federal hearing or federal trial, who's ever there, that's who handles it. Because you're already outside the guise of the state. And this is where most people don't like it. Because when you're dealing with private attorneys who are not working for the government, they're given broad prosecutorial discretion. Why? Because they become super people. Because now their subpoena power is a lot stronger. Because prosecutor of a contempt action who represents the private beneficiary the court order allegedly violated cannot provide insurance. They can't give the government any type of assurance simply because they're there. And they will be guided solely by their sense of public responsibility for the attainment of justice. That's why you go to someone that has nothing to do with that proceeding, has nothing to do. A lot of times, when you're doing wrong, you call them, you get you an out-of-town shooter. And that's how you have to look at this sometimes. You get you an out-of-town shooter who's not tied down by in-town issues. Because such an attorney is required by the very standards of the profession to serve two masters: the court that appointed him or her, and the private client who pays his or her bills. They have to make a decision every time. When I talk about piranha don't eat piranha, guess who they're going to first? Because their first duty is to the court. Then it's to you. Their first duty is to those that feed them. That's why they have a bar card. That's why you go outside of their holding. You don't keep going to the well where all the piranha are when you know right downstream you have clean water. Sometimes you pay for the convenience versus sacrificing an arm for what you know. Because a private attorney appointed to prosecute criminal contempt certainly should be as disinterested as a public prosecutor who undertakes such a prosecution. Why? Because those accused of criminal contempt must, like ordinary criminal defendants, be proven guilty beyond a reasonable doubt. They are afforded the presumption of innocence and privileged not to incriminate themselves, as well as given notice of the charges against them and provided with the assistance of counsel. And the assistance of counsel does not say an attorney. They are afforded the rights of double jeopardy. They are afforded the right to be heard by an outside representative. They are afforded the right to bring forth evidence. They can argue issues. And there's double jeopardy attached to it. Because every action that is done through, as they call it, criminal contempt, is done by the means of violating your constitutional rights. Now, like I said, the last couple of podcasts for this year, they're going to be shorter than pretty much normal. But I want to make sure I keep giving you quality. Because today, we're going to cut this off. But I want you to understand something because I want you to think about something. There's a reason you asked the question of, is it civil or is it criminal? Is there an order in place? You can take it a step further and say, hey, you know what? Go ahead and set it for hearing. I'll be representing my own interests at that hearing. And I'll file a formal motion for discovery in the morning. Because again, every action has to be done through the process. So whenever I hear things such as trust the process, I don't think of the Philadelphia 76ers. I think about understanding how to use the process as a weapon. Because if you're going to hold it as a sword to me, I'm going to hold it as a sniper rifle for you. One shot, one kill. I don't have a lot of time to be dealing with you. I don't want to waste any more time in my life dealing with you than necessary. So that's all I have for today. You guys keep supporting the podcast. Let's keep going. Let's keep growing. I love you guys. And Supreme out.